Welcome to the Occupational Health and Safety Awareness Training module for workers. This training is a requirement as per the Occupational Health and Safety Act. This Occupational Health and Safety Awareness for Workers training was created for organizations and employers to train their employees and all other obligated persons about occupational health and safety awareness as per the requirement set out under the Occupational Health and Safety Act. The content of this module is not legal advice, but does serve to satisfy the requirement for employers to train and educate their employees as required by the Occupational Health and Safety Act. If there is a discrepancy between this training and the Act, or any amendments to the Act that arise after this training has been completed, the Act will prevail. All employees have a reasonable expectation that when they leave their home to go to work, that they would later return home both safe and in good health. Working in a safe and healthy environment is a concept that many of us simply take for granted. For others, working safely is an essential component of their duties. But whether you work at a desk or you work on a construction site, hazards that can dramatically affect your health and well-being are everywhere. In July of 2014, the Ontario government made it mandatory that all organizations provide their employees with occupational health and safety awareness training. Training must be provided to all existing employees and any new employees hired after that date. There will be 2 training courses, one for workers and another specifically for supervisors. This training module is designed to meet the requirements for a worker. The Occupational Health and Safety Act has always required that employers provide an overview of health and safety for new employees or existing employees when required. However, the content of the training that was to be provided was never specified. The new regulation for training sets out a minimum content that must be covered in the training. This training module has been designed to address the specific standards set out in the regulation and outlined by the Ministry of Labour. The format of the presentation was modeled in such a way to follow along with the required topics listed in the regulation so to ensure ease of learning and compliance with the regulation. It must be noted that the requirement to complete occupational health and safety training does not in any way replace other specific workplace health and safety training required under the Occupational Health and Safety Act and its regulations. This module was designed to increase workers' knowledge of basic rights and responsibility under the Occupational Health and Safety Act. When completed, workers should have a better understanding of basic workplace health and safety issues, including hazards and ways to minimize or even prevent the chance of workplace accidents or illnesses. This module will outline the responsibilities of the employer and supervisors as it relates to health and safety, as well as address the rights and obligations of you, the worker. This module will also address the Internal Responsibility System, or IRS for short. The IRS is a concept that basically states everyone, employer, supervisor, and worker, has a vital role in keeping the workplace safe and healthy. Finally, this training will serve to educate and support the health and safety of vulnerable workers. Vulnerable workers generally include young workers, recent immigrants, older workers, or workers new to their jobs or in new firms. New and young workers are 3 times more likely to be injured in the first month of their employment than experienced workers. Thus, it is critical that employees receive suitable training in a timely fashion so to ensure they make it home after work, both safe and healthy. This course has been broken down into 4 core parts. Part 1 will address the foundation of health and safety in Ontario. We will cover the Occupational Health and Safety Act, the role of the Ministry of Labour, the Internal Responsibility System, as well as the rights and responsibilities of all workplace parties as defined by the Act. The second part of this module will cover hazards in the workplace. This part will include the identification of a workplace hazard, the right of employees to know of hazards in the workplace, and the best order of how to deal with them. We will also address the process to be followed if an employee justly has a reason to feel unsafe in performing a duty. Part 3 of this module will speak to the worker's role in the Internal Responsibility System. Every worker has a right to participate in creating and maintaining a safe workplace. We will discuss the varied ways workers can participate. Finally, this module will provide an outline of the resources available to you in both your workplace and externally to ensure a safe and healthy workplace. At the conclusion of Part 1 of this module, workers should have gained an awareness of the Occupational Health and Safety Act, an understanding of the Internal Responsibility System, as well as be aware of the rights and obligations of all workplace parties. The Occupational Health and Safety Act is a set of laws that determines the duties of employers, supervisors, and the rights and duties of employees. It also establishes procedures for dealing with workplace hazards, and it provides for enforcement mechanisms in the case of noncompliance. In short, the Occupational Health and Safety Act exists to keep workers from getting hurt or sick on the job. The Occupational Health and Safety Act also contains numerous regulations that provide for more detailed information and standards as they apply to specific locations, industries, and situations. An example of a regulation would be standards that must be met that apply specifically to construction projects, industrial establishments, or farming operations. An example of a regulation applying to a specific circumstance may be the standards addressing the use of personal protective equipment for firefighters, or the requirements around working with chemicals or hazardous materials. If the heart is said to be the single most important organ required for a human being to live, the Internal Responsibility System, or IRS, could be called the heart or foundation of occupational health and safety legislation. The IRS is a philosophy where everyone has direct responsibility for health and safety as an essential part of his or her job. Whether it be the employer, supervisor, or worker, all parties must strive to do their part to ensure a safe and healthy workplace. Examples of how each party can contribute to a healthy and safe workplace include an employer who ensures all supervisors and workers have completed and understand the necessary workplace safety training and are also trained properly on how to do their jobs. A supervisor who ensures that all the workers under his or her authority are performing their duties safely, which may include ensuring they are using personal protective equipment, using ladders properly when required, or not condoning harassment and violence in the workplace. Examples of a worker fulfilling their role within the internal responsibility system may include reporting a hazard to their supervisor or informing the supervisor of another employee who is working unsafely. Everyone has an important role to play, and the duties and obligations of all workplace parties are formalized in the Occupational Health and Safety Act. The Act first outlines the duties of the employer in sections 25 and 26. This slide lists a few of the more important duties, but not all the obligations as set forth in the Act. You will notice that as the employer is the party with the most authority in the workplace, they also have the most responsibility. Thus, the obligations placed on the employer are both broad and important. Some of the duties of the employer as outlined in the Occupational Health and Safety Act are to take every reasonable precaution to ensure the workplace is safe, to train all employees about any potential hazards, how to handle them, and how to handle emergencies. The employee also must be shown how to safely use, store, and dispose of hazardous substances. The employer must provide personal protective equipment and ensure workers know how to use the equipment safely and properly. Depending on the number of employees, the employer must create and maintain a joint health and safety committee. The number of employees will determine whether a committee is required and the number and composition of the committee. Alternatively, the employer is responsible to ensure the employees select at least one health and safety representative. Joint health and safety committees and health and safety representatives will be discussed in more detail later in this module. Employers must ensure that all critical injuries are reported immediately to the government department responsible, and they must appoint a competent supervisor who is responsible to ensure safe working conditions, actions, and behaviors. In order for a supervisor to be deemed a competent person, they need to meet 3 standards. The term competent person, as defined by the Occupational Health and Safety Act, means a person who is qualified because of knowledge, training, and experience to organize the work and its performance, is familiar with this act and the regulations that apply to the work, and has knowledge of any potential or actual danger to health and safety in the workplace. After the employer, the Act then addresses the duties of the supervisor in Section 27. A supervisor is a person appointed by the employer who has charge of a workplace or authority over a worker. Again, you may notice that as the authority of a supervisor is less than that of an employer, the duties and obligations listed in the Act become less broad and more specific. Nevertheless, as managers and supervisors act on behalf of the employer, their duties and obligations are no less important. The duties of the supervisor as per the Occupational Health and Safety Act are that they must ensure that workers use prescribed protective equipment, devices, and clothing that are provided by the employer. The supervisor must also ensure that these devices are used appropriately. Supervisors must advise workers of potential and actual hazards that they are aware of in the workplace. If necessary, the supervisor must provide written instructions about the measures and procedures to be taken for the worker's safety. And supervisors must take every reasonable precaution in the circumstances for the protection of the workers. The last obligation listed in this slide is both a broad and important requirement. In a case where a supervisor may be challenged that they did not take every reasonable precaution in the circumstances for the protection of workers, the supervisors can claim the defense that they indeed performed their due diligence. In doing so, the supervisor must be able to prove that all precautions, reasonable under the circumstances, were taken to protect the health and safety of the worker. Last, but certainly not least, the Act addresses the duties and obligations of the worker in Section 28. These duties are far more specific than those of the employer and supervisor. The bulk of the obligations relate to the worker's own conduct as it relates to health and safety. However, as you may notice, the Act does prescribe duties on the worker that impact the larger workplace and other employees. Under the Occupational Health and Safety Act, a worker must work in compliance with the Occupational Health and Safety Act and regulations. They must use personal protective equipment, devices, and clothing as directed by the employer. This also includes using these items appropriately. The Act states that a worker cannot remove or make ineffective any protected device required by the employer. An example may be wearing a hard hat backwards, which may lessen the effectiveness of the headgear if struck. The worker also has a responsibility to report workplace hazards and dangers. This includes reporting contraventions of the Act, which may include reporting fellow employees who are being unsafe or non-compliant. And workers may not use or operate any equipment or work in a way that may endanger any worker. The Act goes on to state that inappropriate behaviors in the workplace that may pose a safety risk are not permitted. Examples of such behaviors can range from racing forklifts around a warehouse to carelessly shooting elastics in the direction of a coworker's head in an office environment. Something unique to the Occupational Health and Safety Act as it relates to employees is that they are afforded 3 basic rights. These 3 rights are often referred to as the 3 R's. The first is the right to refuse unsafe work. The next R is the right to participate in the promotion, education, and implementation of health and safety initiatives in the workplace. This is most often witnessed via participation through the Joint Health and Safety Committee or as a worker health and safety representative. Finally, employees have a right to know, or rather, the right to be informed about actual and potential dangers in the workplace. Another important right of employees, as stated by the Act, is security against retribution from a supervisor or employer, which results out of an employee being compliant with the Act or engaging in any of the 3 rights outlined in this slide. As we move through this module, the 3 R's, as well as the right to fear no retribution, will be discussed in greater detail. It would be difficult to dispute that workplace accidents happen. On the other hand, one would draw much dispute if it was said that workplace accidents happen and there is nothing we can do about it. Critical to the success of the internal responsibility system is that everyone must accept that accidents and illnesses have causes that can be eliminated or greatly reduced. In large part, these causes are workplace hazards. Part 2 of this module will begin by answering the question, what is a workplace hazard? We will then address the employee's right to know about hazards and dangers that exist in the workplace. We will then discuss the role of the employer in eliminating, reducing, controlling, and protecting you from workplace hazards. We will address other places where you can find out more information about workplace hazards, such as policies, processes, and training. Finally, we will speak to the worker's right to refuse unsafe work. Key discussion points regarding work refusals will be what constitutes unsafe work, when it is appropriate to refuse work, what the process is to do so, and your protection against reprisal from the employer. So what in fact is a workplace hazard? When thinking about the answer to this question, most people might think of physical dangers or risks. A few things that may initially come to mind might be working on machinery, heavy or sharp objects, perhaps dangerous chemicals that would burn your skin if exposed. All of those examples are indeed hazards, but there are so many more hazards that are far less common or obvious. A hazard, as it relates to the workplace, can be defined as any source of potential damage, harm, or adverse health effects on something or someone under certain conditions at work. Hazards can cause harm or negative effects to a person's health or property. They exist everywhere, but it is in the proper identification of hazards and the actions to eliminate or control them that accidents in fact can be reduced or even prevented. Common hazards are those dangers which most people can readily identify. Common hazards may include lifting or carrying heavy objects, slips, trips, and falls, working at heights, working in or on motorized vehicles or machinery. All of these hazards are well known to most employees, and many employees have encountered them at some point in their job. Less common hazards might include noise and lighting levels, workplace harassment and violence, or chemicals and occupational diseases that you may not even know exist. Another very common hazard is repeated motion or doing the same movement numerous times. Examples of repeated motions seem easy to identify in a warehouse or industrial environment. However, it does not always occur to some that tasks associated with working in an office, such as typing, working on computers or the phone, the manner in which your workstation is set up, all constitute hazards, and the potential harm an employee can suffer from these repeated movements can be very damaging and long-lasting. One of the specific topics that this training module must address to satisfy the regulation is instruction on occupational illness, including latency. Occupational illness is a sickness that was caused because of or due to exposure in the workplace. Under the Occupational Health and Safety Act, occupational illness is defined as a condition that results from exposure in a workplace to a physical, chemical, or biological agent to the extent that the normal physiological mechanisms are affected and the health of the worker is impaired. Examples of an occupational illness or disease that have been documented include asbestos, dermatitis, occupational asthma, tuberculosis, hepatitis, influenza, chickenpox, noise-induced hearing loss, and certain types of cancer. Occupational illnesses are rarely acute and generally develop over time. Latency refers to the concept that some occupational illnesses may not be immediately apparent or known. It is common in the diagnosis of many of the illnesses noted on this slide that there is a period of time, sometimes years or even decades, between initial exposure to the hazard and the appearance of an illness or disease. The employer has an obligation to report occupational illnesses to the Ministry of Labor. In addition, the Workplace Safety and Insurance Board may provide benefits and income replacement in the case an illness or disease is proven to be work-related. It is important that both employers and employees know their obligation to report to the required government agencies in the case of an occupational illness. One of the 3 R's that was discussed earlier in this module is the right to know. All employees have a right to know what hazards exist on the job or in the workplace. They also have a right to know how these hazards can affect them. It is the obligation of the employer to train employees about hazards in the workplace upon hire with your organization. Learning about chemical safety through WHMIS, the Workplace Hazardous Materials Information System, is an example of training that must be provided for new and existing employees. Training on hazards should continue as the employee learns the duties of their position and when new hazards should arise throughout the course of employment. Employees also have a responsibility to report hazards to their supervisor or employer should they become aware of them. It is critical to the success of the concept that is the internal responsibility system that employees do their part. Hazards can arise in specific circumstances or may have simply not been spotted before. Reporting a workplace hazard when you become aware of it is not only the law, it is an essential aspect to reducing or preventing workplace accidents and injuries. Once workplace hazards are identified, it then falls upon the employer to take the necessary actions to eliminate, reduce, or control them. What you see in the slide is commonly referred to as the hierarchy of control. As with any hierarchical system, it is viewed or implemented as a top-down approach. At the top of the list, and therefore the first control that should always be attempted, is the elimination of the hazard. It is as simple as it sounds. If the hazard can be eliminated, it is simply removed from the workplace. Similarly, replacing the object or process that is causing the hazard with an object or process that poses a lesser or no risk at all also amounts to eliminating a hazard from the workplace. Should the elimination or substitution of the hazard not be an option, the next consideration would be to reduce the risk and potential impact of the hazard. This step is also referred to as engineering controls. Engineering controls may include modifications to equipment, ventilation systems, or processes that reduce the source of exposure. An increasingly common example you may encounter in workplaces are mechanical lifting platforms, where the worker may alter the height of the platform so to work at a comfortable level conforming to the size of the job and their own height. Instituting administrative controls is the next consideration in the hierarchy. Administrative controls alter the method and process which govern the way work is done. Occupational workplace health and safety training is an example of an administrative control, albeit a required one. The idea is that all of you will incorporate the important information that is outlined in this module, and by putting it into practice, you will be aware of hazards and work safer. Other examples of administrative controls include timing of work policies, maintaining the cleanliness of the workplace and workstations, anti-workplace harassment and violence training, and the proper and timely maintenance of machinery and equipment. Finally, when all the necessary steps have been taken to eliminate, reduce, or control the hazard, the employer must turn their attention away from the actual hazard and focus on the protection of the worker. Personal protective equipment is equipment worn by individuals to reduce exposure of hazards, such as contact with chemicals or exposure to noise. Common examples of personal protective equipment include hard hats, safety glasses, steel-toed footwear, or earplugs. Personal protective equipment can be considered the last line of defense. After the employer has done everything reasonable within their power to eliminate or reduce the risk of dangers in the workplace, equipment that physically and literally protects the worker reduces the risk of injury or illness. The employer's obligations concerning the right to know are many and important. They must do the following: inform all workers about specific or potential hazards in the workplace and ensure that they do everything reasonable so workers are safe. They must develop, implement, and train workers on the procedures to follow to report health and safety concerns, workplace incidents, and workplace injuries or illnesses. This includes training on how to report an injury to the Workplace Safety and Insurance Board. They must identify which personal protective equipment is required and provide it to the workers. and they must ensure adequate first aid supplies and stations are available in the workplace. They must also train the required amount of workers in first aid and post their names and relevant information in the workplace. Employer policies, formal processes, and required training are all resources that supervisors and workers can rely on when looking for direction or answers regarding health and safety. Of note, the following list is not exhaustive of the employer's obligations, and the employer should take the appropriate steps to ensure they are in compliance with the applicable workplace legislation. All employers are required to have and post a health and safety policy. This module satisfies the requirement that employees be trained in occupational health and safety awareness. However, there are numerous job and sector-specific health and safety training requirements that are required to be provided in addition to this awareness training. Examples may include forklift training, working at heights, ladder safety, etc. Other policies that are required by the Occupational Health and Safety Act are WHMIS, and if you have 5 or more employees, an anti-workplace harassment and violence policy. The Act also requires that the employer train their employees on both topics. In addition, the employer must also post the names and contact information of the members of the Joint Health and Safety Committee, the health and safety representative, and the employees who have been trained to provide first aid in the workplace. The employer also must inform employees of how they report a workplace incident, injury, or illness, as well as the process to file a claim with the Workplace Safety and Insurance Board. This should be done via a formal policy or process. Finally, the employer must post in a common area to all employees a copy of the Occupational Health and Safety Act, as well as the following posters: Employment Standards in Ontario, Health and Safety at Work, Prevention Starts Here, and, if applicable, an In Case of Injury poster which speaks to the reporting process for the Workplace Safety and Insurance Board. The Workplace Hazardous Material Information System, most commonly referred to as WHMIS, was designed to inform workers and employers of hazards associated with the chemicals and substances that they may come into contact with in the workplace or in the course of performing their duties. WHMIS outlines requirements that dictate how information on hazardous materials is to be provided. Information is provided in 3 ways. Labels must be on the containers of hazardous materials. Material safety data sheets, commonly referred to as MSDS, must be available in the workplace. MSDS provide detailed hazard and precautionary information about the product. The supplier of the hazardous material provides the MSDS to the employer, who in turn must make them available to employees. Finally, the employer must provide all workers with an education or training program. The training program must be provided to all workers for employers who have a designated substance in the workplace, or if the worker may be exposed to a designated substance in the course of performing their duties. WHMIS is changing. Changes have been made to the legislation to incorporate the Globally Harmonized System, or GHS for short, into WHMIS. With the addition of the GHS, the new WHMIS requirements will be referred to as WHMIS 2015. WHMIS 2015 is presently in force, however the requirements are being phased in. Currently, suppliers may begin to use the new system. Employers must train workers about WHMIS 2015 over a reasonable time frame after new labels and safety data sheets appear in their workplaces. Employers must comply with WHMIS 2015 by December 31st, 2018. During the transition period, employers may continue to train in the WHMIS 1988. The second right of all workers, as mentioned earlier in this module, is the right to refuse unsafe work. Where the worker has a legitimate claim to feel unsafe in performing their duties, the Occupational Health and Safety Act provides for a right to refuse work. This includes if the worker believes they themselves are in danger, another person may be at risk, or if they feel endangered by the risk of workplace violence. Some jobs come with a significant responsibility and care for others. These jobs often place employees in dangerous positions, and the right to refuse work is limited to those workers in certain circumstances. These workers include police officers, firefighters, workers employed in the operation of correctional institutions and similar institutions or facilities, and most types of healthcare workers and other subsidiary workers in numerous types of facilities, including, but not limited to, hospitals, nursing homes, paramedics, homes for the aged, mental health centers, etc. Refusing work is a serious action, one that should not be taken without good reason by any worker. Simply not wanting or feeling like doing an assigned duty is not a valid reason to refuse to do your job. The Occupational Health and Safety Act sets out certain conditions in which a worker may refuse work. In a case where a worker has reason to believe that any machine, equipment, or tool that the worker is using or is told to use is likely to endanger themselves or another worker, the physical condition of the workplace or workstation is likely to endanger themselves, workplace violence is likely to endanger themselves, or if any machine, equipment, or tool that the worker is using or the physical condition of the workplace contravenes the act or regulations and is likely to endanger themselves or another worker. A few examples of what may be considered legitimate reasons to refuse work may include being asked to work on a cutting machine that does not have the appropriate guarding so to ensure your hands or clothing do not get caught or cut. Be asked to use a tool or machinery that requires that you first be trained in the safe usage of the tool. For example, being asked to use a chainsaw or drive a forklift without necessary training. In cases of workplace violence, for example, a scenario where an employee was physically threatened by another employee and they work in the same office. In all these cases, a worker has a right to refuse to perform the assigned duty or work in that environment. At this point, the worker may engage the work refusal process. In the case where a worker does refuse work, there is an established procedure that must be followed as per the Occupational Health and Safety Act. The Act breaks down the procedure into 2 steps. The first step is a process where the work refusal is mitigated internally. The second step follows if step 1 was not successful and involves the intervention of the Ministry of Labor to decide on the dispute. When a worker first makes a determination that they feel unsafe, they must immediately inform a supervisor or the employer and explain the circumstances for the refusal. The supervisor or employer must investigate the situation immediately. During the investigation, the employee must remain present, albeit in a safe place, and must be joined by one of the following: a worker member of the Joint Health and Safety Committee. Ideally, the certified worker member would be present, a health and safety representative, or an alternative worker who, because of their knowledge, experience, and training, has been chosen by the worker or union to represent the worker making the refusal. Ideally, this is where the dispute would end. The employer may find that the employee has no grounds for a refusal, or they may find that there is a legitimate concern and take the appropriate actions. In the case where the employer finds no issue, the employee still may refuse to work if they feel their concern is still legitimate and has not been addressed. At this point, the refusal moves to Stage 2. Stage 2 is the point where the Ministry of Labor gets involved. Once the employee has continued the refusal past the employer's investigation stage, the Ministry of Labor must be notified. The worker refusing work must remain on site and available, but always in a safe place. Another worker may be asked to perform the job, provided they have been informed of the details of the work refusal and the outcome of the employer's investigation. The second worker may decide there is no danger and take on the job, or they too may refuse the work. The Ministry of Labor representative will perform an investigation and provide their decision in writing. The decision generally is either that no danger exists and work must commence, or that changes need to be made to make the job safe. Section 50 of the Occupational Health and Safety Act expressly prohibits the employer from acts of reprisal or acts that are punitive against the employee in response to the worker utilizing their rights or carrying out their duties under the Act. Examples of reprisal may include unwarranted termination, layoff, discipline including suspension, demotion of any kind, whether it be in title, money, or responsibility, the threat of any of the before-mentioned actions, or general intimidating or coercive behavior. Workers who feel as though they have suffered reprisal may contact the Ontario Labour Relations Board to submit a complaint. Part 3 of this module addresses your role in the internal responsibility system. We have already discussed the first two R's, or rights of workers, the right to know and the right to refuse. In this section of the module, we will discuss the third fundamental right of a worker, the right to participate. A worker's right to participate is an essential component of the internal responsibility system. Being active can be as simple as asking a question about health and safety or pointing out a potential hazard. For others, participation may mean being an active member of your Joint Health and Safety Committee. Whatever role you decide, your right to participate is important and should not be taken for granted. In this section, we will discuss your right to participate in all aspects of workplace health and safety. We will provide examples of how workers can participate in the workplace. We will also address the role, duties, and obligations of Joint Health and Safety Committees and health and safety representatives in the workplace. The right to participate is exactly how it sounds. You, the employee, have a right to participate in all things regarding the health and safety of the workplace. Basically, the right to participate speaks to your right to be active in your workplace regarding matters that promote and ensure health and safety. Participating is more than simply being involved in current processes or committees. It is an opportunity for workers to be engaged in the planning process. Workers are provided with the opportunity to shape health and safety practices. After all, it is the workers that are most likely to encounter potential hazards each day. Becoming a member of your organization's Joint Health and Safety Committee, or for smaller organizations, representing your peers as a health and safety representative, is the primary way this right is expressed. However, there are many other ways, most of them rather simple, that you can participate in the promotion of a safe and healthy workplace. Perhaps the best and most effective way you can participate in the workplace is to ensure that you ask questions that need to be answered regarding health and safety. For example, do you know what you should do in the case of a workplace incident? Do you know who your first aid representative is? Do you know what you should do or where you should exit in the case of an emergency? And perhaps the most important question that should be asked by new employees or when taking on new duties is, tell me everything I need to know how to do my job safely. This is your right. The right to be safe through participation, which is as simple as asking the question. Other ways that you can participate in the promotion of health and safety in the workplace include making your supervisor aware of existing or potential hazards. Take your health and safety training seriously. Abide by it and institute the lessons you have learned into workplace practices. Participate in additional health and safety training or courses if available. Often employers will offer or provide additional training that is not required but suggested. Be sure to participate when you have the opportunity. And actively promote wellness in your workplace. Workplace wellness programs have become commonplace, and participating through maintaining your own healthy lifestyle, going on group walks at lunch with your peers, or even being part of a wellness committee are all excellent ways to participate in the overall health of your workplace. And do keep in mind, even if your workplace does not have a formal wellness program or initiatives, there is nothing to stop you and your peers from being healthy workers in promoting a healthy workplace. The right to participate is primarily expressed through membership and the role of the Joint Health and Safety Committee or Health and Safety Representative in the workplace. The primary role of the Joint Health and Safety Committee is to identify workplace health and safety issues and bring them to the attention of the employer. Not every employer is required to have a committee, and the required composition of the committee varies depending on the size of the organization. Organizations that are required to have a Joint Health and Safety Committee include any workplace that regularly employs 20 or more workers, construction projects expecting to last 3 months or longer with 20 or more employees, any workplace other than a construction project to which a designated substance regulation applies, any workplace where an order has been issued dealing with toxic substances, and any workplace where the Ministry of Labour orders one to be established. A Joint Health and Safety Committee must be composed of both management and worker members. Organizations that have 20 employees but less than 50 must have a minimum of 2 members. Organizations that have 50 or more employees must have a minimum of 4 members. In all cases, at least half the members of the committee must be worker members who perform no management function. Worker members are selected by their peers or union, and management members are selected by the employer. These numbers are minimum requirements as set out by the Occupational Health and Safety Act. It is becoming more common, especially in larger workplaces, that the minimum number of members of health and safety committees are exceeded. At least 2 members, 1 worker and 1 management member, must be certified in health and safety. In order to be certified, a person must complete the parts 1 and 2 of mandatory training, basic certification, and workplace-specific hazard training. Refresher training is required every 3 years to maintain certification. There are only certain companies that are able to provide this training to employers. A list can be found on the Ministry of Labour website. A meeting of the Joint Health and Safety Committee must be held every 3 months and more often if required. Joint Health and Safety Committees have an important role in the development, awareness, and maintenance of health and safety in the workplace. There are numerous important functions that Joint Health and Safety Committees have the obligation and authority to carry out. The core function of all committee members is, of course, to represent and be available to their peers. This includes receiving worker concerns, complaints, and recommendations. The committee would also discuss health and safety issues, as well as develop and recommend solutions to the employer. In addition to these core functions, Joint Health and Safety Committees have numerous legislative powers. They are responsible to identify actual and potential hazards in the workplace, investigate work refusals and serious accidents, obtain information from the employer relating to health and safety in the workplace, conduct workplace inspections on a regular basis, post the results of the inspection, and make recommendations when necessary. Inspections must be carried out at least once a month. In some workplaces, inspections can be done monthly to only parts of the facility if prior approval is provided by the Ministry of Labour. The committee must be consulted in regards to any health and safety testing that is conducted in the workplace. Moreover, a worker representative must be present at the commencement of the testing and be present to represent a worker when required. Finally, the Joint Health and Safety Committee also recommends health and safety improvements in the workplace. As stated, not all organizations are required to have a formal Joint Health and Safety Committee. For those employers who have 6 employees but less than 20, they are required to have a minimum of 1 health and safety representative. This representative must be selected by the workers. For those employers that have 5 or less employees, they require neither a committee or a representative. For the most part, the Health and Safety Representative has the same powers as that of the Joint Health and Safety Committee. An important note: at the time this module was created, there was no requirement to provide specific formalized training or certification for a Health and Safety Representative. However, amendments to the Occupational Health and Safety Act had been passed requiring specific training for workers who held this role. These amendments, while passed, had not come into effect at the time this module was created. Employers should be diligent to determine whether their health and safety representative requires formalized training or certification at the time of viewing this module. Part 4 of this module outlines the external health and safety resources that are responsible for the promotion and enforcement of the health and safety system in Ontario and are available to both worker and employer. The regulation regarding the Occupational Health and Safety Awareness Training mandates that the content must include an overview of these agencies under the Occupational Health and Safety Act. The Occupational Health and Safety Act provides for enforcement mechanisms in the case of non-compliance by an employer, supervisor, and even a worker. The Ministry of Labour was established in 1919 to develop and enforce labour legislation. This ministry has grown to provide more than just the strong arm of enforcement. The ministry also serves to communicate workplace standards and encourages greater self-reliance for employers through the numerous resources and initiatives they undertake. The ministry partakes in a range of initiatives, from supporting mental health in the workplace to collaborating on collective bargaining. In addition, the ministry also develops and implements strategies for injury and illness prevention and can set standards for health and safety training. Nevertheless, the primary role of the Ministry of Labour is indeed still the promotion, communication, and enforcement of the Occupational Health and Safety Act. The ministry also enforces the Employment Standards Act, which outlines requirements related to fair employment practices, and also administers the Labour Relations Act. The ministry has the authority to issue warnings and fines to all workplace parties. Penalties for employers are far greater for those of a supervisor, and the supervisor's penalty greater than that of a worker. The ascending cost of penalties is representative of an important lesson from the Occupational Health and Safety Act. The more authority someone has in the workplace, the greater the responsibility, and in turn, the larger the consequence. The Ministry of Labour is only one of the numerous health and safety government partners that exist to assist employers to create and maintain a safe workplace. The Workplace Safety and Insurance Board is essentially an insurance company for employers. Employers are provided with no-fault collective liability insurance and receive health and safety information and resources that are specific to their industry. Workers of covered employers receive loss of earnings benefits and healthcare coverage in the case of a workplace accident or illness. In the case of the WSIB system, no-fault insurance means that no matter how a worker is injured or whose fault it may be, with a few rare exceptions, should they suffer a workplace injury, they will receive entitlement if their claim is allowed. In turn, an employee who is eligible to collect this benefit may not sue their employer. For the vast majority of employers in Ontario, participating in the WSIB insurance program is mandatory. Recently, the Ontario government passed legislation that made coverage mandatory for most employers in construction as well. With the exception of a few rare occasions, the WSIB insurance program is available to all employers and their employees. In addition to the Ministry of Labour and the Workplace Safety and Insurance Board, Ontario's prevention system is made up of the Workers' Health and Safety Centre, occupational health clinics for Ontario workers, and 12 health and safety associations. The Workers' Health and Safety Centre provides occupational health and safety promotion programs and training primarily for joint health and safety committees, health and safety representatives, workers, and supervisors. The Occupational Health Clinics for Ontario workers utilizes interdisciplinary healthcare teams and clinics, which provide comprehensive occupational health services and information. Their key areas of service are answering work-related health and safety questions, medical diagnostic services for workers, group services for workplace health and safety committees and groups of workers, education and awareness of health, safety, and prevention, and services to investigate and report on illnesses and injuries. Health and Safety Ontario is comprised of 4 sub-agencies, which serve to streamline the services provided by the 12 health and safety associations working for you in Ontario. Their focus is to provide health and safety expertise and best practices, innovative and cost-effective solutions, sector-specific products and services, as well as information, advice, and training for employers and their employees. You have completed the assigned training module. You will now be required to take a quiz to affirm your completion and understanding of the content of this module. A score of 70% is required to pass the quiz. Upon completion of the quiz, you will be notified if you have passed or if you are required to take the training again. You are permitted one additional opportunity to repeat the training and pass the quiz should you fail the first time. Good luck.